Hi. Now I am going to discuss on banker-customer relationship, a topic of banking law and negotiable instruments, a subject of fourth semester 3Y-LLB course. I think it's unit 3, banker-customer relationship. Now we have already, in the introductory chapter, we have already discussed about the definitions of various definitions on banking. And who is a banker? A banker is a person who in the ordinary course of his business honors the checks drawn upon him by persons from and for whom he receives money on current accounts. This is what the definition I have given or we have discussed, and that is the definition of Dr. H.L. Hart. And when we proceed to the definition of Sheldon, we find it in the following words. The function of receiving money from his customers and repaying it by honoring their checks as and when required is a function above all the other functions which distinguishes a banking function from other kind of function or business. And we have also referred to Crowther. A banker is a dealer in debt, his own and other people's. Then we have referred to Section 5 Clause 1 Clause C of the Banking Regulation Act 1949, which defines banking as accepting for the purpose of lending or investment of deposits of money from the public and repayable on demand or otherwise and withdrawable by check, draft, order or otherwise. So I think nearly 5 or 6 definitions we have referred to as to what we mean by the term banker. And in the very Banking Regulation Act, Section 5, it defines banking as acceptance for the purpose of lending or investment of deposits of money from whom? From the customers. And it is required to be when it is acceptance for the purpose of lending or investment of deposits of money from the public, which is repayable on demand or otherwise and withdrawable by check, draft, order or otherwise. Banker accept the deposits from the public, and banker accept with the deposits accepted from the public. A banker carries on his main banking business, that is lending or investment. Whatever the money that is deposited to the banker, that is always withdrawable or repayable to the customer in the approved forms. That is what is required. Dr. H.L. Hart or Section 5 or Crowther's definition holds good. But now, after having referred to the definitions of banker or banking, we should know the definitions of customer. Who is a customer? There are definitions. John Paget view, to constitute a customer, there must be some recognizable course of action, or there must be recognizable course of or habit of dealings in the nature of regular banking business. What is that regular banking business? We all know regular banking business constitutes like acceptance of money and lending, acceptance of deposits and lending of such money. And in order to constitute any person as a customer, then there must be some recognizable course or habit of dealings in the nature of regular banking business is what Sir John Paget's definition means. So therefore, in order that a person to be a customer of the bank, 2 conditions should be there according to the definition of John Paget. And the first condition is with reference to duration. That is, there must be some recognizable course or habit of dealings between the person who is called the customer and the banker. What is that duration? Simply opening the account is not enough according to this. And you must maintain and you must ensure that the account is operational for a considerable course of time. And after opening the account, if the account is not at all operated, and on account of this, since it is not been operated for a duration, it has been opened and account is existing, it is not enough for constituting a person as a customer of the bank. Therefore, duration theory insists on dealings between the customer and the bank for some duration of period, and if that duration of period is not complied with, and if it is not existing or present, then it will not constitute that person as a customer, is what the first condition says. But the same condition discarded or rejected later, and it is enough for the relationship of the banker and customer begins as soon as the account is opened, is what the conclusion. And the second condition of Paget's definition is that regular banking business. What is that regular banking business? Transactions of the dealings between that person, in bracket you can add customer, and the bank must be in the nature of regular banking business. That is, dealings or transactions between the person and the bank must be regular banking transactions and not casual transactions. Examples of regular banking transactions are acceptance and repayment of deposits and lending of funds. A casual, paying of, you go to the bank so as to, pay for life insurance corporation or electricity bills or, water bills or purchase of some draft or traveler's checks, etc. These are all, casual transactions that can be, had by any person even without having an account. But for a person to be constituted as a customer, he must have some account with the bank. According to the second condition, a customer means a person who must be in the habit, who must have invoked the regular banking business type of nature of function of the bank. A customer is Dr. H.L. Hart defines a customer is one who has some account with the bank. If he opens an account, then he is a customer. And whether for how long, on what all occasions and for how many times he has to operate that. If regular banking business is not carried on a regular basis by the customer, just by having an account with the bank is not enough. That's what Paget said, but Chalhart said it is simply enough to constitute a person as a customer if he has opened an account with the bank. And the casual transactions will not constitute in case if any person invokes the casual transactions with the bank or transacts certain transactions with the bank without having an account with the bank, then it will not constitute him as a customer of the bank as such, as I refer to LIC or electricity bills or water bills or traveler checks or circular notes or deposits of valuables for safe custody, etc. There, if you go for the invoking these functions of the bank, it will not constitute you as a customer. Therefore, to make a person a customer of the bank, the essential requirement should be satisfied, and such requirements are the following. One, he should have some sort of an account, say a savings account or fixed account or recurring account or the current account, as the case may be. And then there need not be duration or dealings between the person and the banker. Even a single transaction can make a person as a customer of the bank. There is no need of a frequency of transactions between the customer and the bank so as to make that person as a customer of the bank. Frequency of the transactions as required in the definition of John Paget is not at all required. The frequency of transaction between the two is anticipated, but it is not insisted upon to make the person as a customer. The dealings between the banker and the customer should be that of banking nature and not a casual nature. So we have discussed about the definitions of banker and customer. Having referred to the meaning of banker and customer, and when a person will be constituted as a customer and what all the essential requisites of customer, we should know now about their relationship. The relationship between banker and customer may be divided into two types. They are general relationship and subsidiary relationship. It is very interesting in the examinations of the universities, questions will surely come that explain the general relationship between banker and customer, or it could be like the relationship between banker and customer is primarily that of debtor and creditor. Explain, or they may also refer to any of the obligations arising out of the relationship, either the obligation of that of the customer or that of the banker. By quoting any of these obligations, they may frame a question like discuss. So it is very interesting and very easy as well to expand the relationship between, to substantiate or to describe the relationship between banker and customer. Essentially, it is of two types, namely general relationship and special relationship. The general relationship, let us now discuss about the general relationship between banker and customer. General relationship between banker and customer is of two types. Again, one is primary relationship, another one is subsidiary or secondary general relationship. There are two relationship existing between the banker and the customer. One is general, another one is special. Normally, when the account is opened, when the account is opened by the customer with that of a banker, it will constitute the banker as a debtor and the customer as a creditor. And what type of creditor? It's a general creditor. But when the account is overdrawn, or when the loan is availed by the said customer from the bank, it will turn the customer to that of debtor and the banker to that of creditor. It all depends whether there is a credit balance or debit balance. When the customer's account shows credit balance, then the customer is a general creditor. When the customer's account shows debit balance, then customer becomes the borrower or the debtor. So it depends. John Paget defines like the relationship between banker and customer is primarily that of the relationship between banker and customer is primarily that of debtor and creditor, but the respective relationship is defined by the existing state of account, is what John Paget has defined. It's a beautiful definition. The relationship between banker and customer is primarily that of debtor and creditor, the respective positions being determined by the existing state of account. So you cannot blindly define that when the account is opened, banker is a debtor, customer is a creditor. It all depends upon what is the present state of the existing status of the account. If it has credit in its balance, then as you said, banker is a debtor, customer is a creditor. But when the account is overdrawn, banker is not the debtor, banker becomes the creditor, and customer becomes the debtor as such. So it depends. So the the general relationship is again divided into two. Special relationship, as you know, special relationship will evolve from the general relationship only. Usually, the special relationship refers to the rights and obligations of the banker and customer. In case of general relationship, the general relationship between banker and customer, it is divided into primary general relationship and subsidiary general relationship. When we say primary general relationship, we will refer to certain terms, that whether banker is a bailey of customers' money, whether banker is a trustee of customers' money, whether the banker is the agent of customers' money, whether the that way. As far as the subsidiary relationship subsidiary general relationship is concerned, a banker is a bailey, a banker is an agent, a banker is a advisor, a banker is a trustee as such. But to the main function of banking, that is acceptance of deposits and lending of funds, a banker is not at all a bailey, agent, or a trustee of customers' money. The nature of that primary general relationship we will see. When a banker receives deposits of money from the customer, he is neither a bailee, nor a trustee, nor a agent, but he is only a debtor. As John Paget puts it in these lines, the relationship between banker and customer is primarily that of the debtor and creditor, the respective positions being determined by the existing state of account. To say that money is deposited with a banker is likely to cause misapprehension. To say that when the money is deposited in the account and the same money is to be repaid as and when it is required by the customer, it will result into some sort of failure in the main banking business as such. A banker is not at all a bailee or depository of customers' money. As soon as account is opened, as soon as the amount is deposited by the customer to his account, it will not constitute the banker as a bailee or merely a depository of customers' money. This is because a bailee accepts the bailment of certain things. You know the meaning of bailment. In case of bailment, when the particular subject matter, either good or whatever, when it is accepted, and it is accepted for a particular use upon the agreement that when the use is over, it shall be returned to the same shall be returned to the the bailer by the bailee. And if any damage is caused, then the bailee is liable for those damages. It is not so. A banker is not the bailee of customers' money. He is not expected to return the same money or same coin that is deposited by the customer to his account. But no doubt he is expected to repay as and when it is wanted by the customer during the business hours. He is expected to repay them. He should allow the withdrawal. He will repay the amount deposited. Not only he will repay the amount deposited, he will also pay him the interest in respect to the deposits which the customers have made. But he is not at all expected to repay or return the same money or identical money. If that is done, then he cannot run his main banking business, that is lending of funds, and earn income for himself from the money deposited by the customer. So therefore what is expected is that a banker is not a bailee or depository of customer of money. He is only expected to return to the customer when it is wanted by the customer. He is expected to return equivalent to value and not the same money as such. Therefore a banker is not bailee. Banker is not even a trustee of customers' money. When the money is deposited to the account, when the money is deposited by the customer to his account, the banker is at liberty to administer that money. Banker is at liberty to apply that money for carrying on his main banking business. He may lend, he may invest. He is not bound by any of the instructions of the customer. A banker is not a trustee of customers' money. This is because a trustee is required to use the trust money in accordance with the trust deed. But a banker is not bound to use the money in accordance with the customers. The banker is not bound to use the money for customers' benefit. He uses the money for bank's benefit. When the bank is benefited, obviously it would benefit the customer. There is an obligation on the part of the banker is to return the money with the interest, which banker will do. And customer, while depositing the money, either while opening any sort of account, whether it is savings account or fixed account or some other form of account, a customer cannot instruct as far as the main banking business is concerned. As far as the main primary general relationship is concerned, a customer cannot be the beneficiary, and the banker cannot be the trustee for the banker to apply the said money for the customers benefit as such. The banker is at liberty to administer the money for carrying out his main banking functions, and he is not bound by the customer as such. Then again, banker is not even the agent in respect of customer's money. When the banker accepts the deposits of money from the customer, he is not an agent to the customer. This is because the agent is bound to act according to the instructions of the principal while investing the principal's money. And he should render the accounts to the principal, etc., etc. But a banker is neither required to invest the customer's money according to the instructions of the customer, nor is he bound to render any account for everything he does with the customer's money. Again, he is not required to return the customer all the incomes he earns from the use of customer's money. No, he is expected to return only his money along with the agreed rate of interest and nothing beyond. The banker may earn more, which in the case of a normal agency, agent is bound to disclose to the principal of whatever earnings that he has. And he is bound to disclose to the principal in good faith. If he earns extra, he will have to return to the principal. It's what the obligation of the agent towards the principal in normal agent principal relationship. But it is not so. A banker is not the agent that way. He is at liberty to use the money, and he is not bound by the instructions of the customer as far as general, main bank, the primary general relationship is concerned. That is, in case of primary general relationship, Paget defines that relationship with the banker is primarily that of the debtor and the creditor. When he becomes a debtor, when the account is opened and money is deposited into the account, with that money, banker can apply that money for either any form of lending or investment, and where it is to be applied upon, etc. He is not bound. He is not the agent of the customer, so as to constitute the customer as the principal. He is not bound by any restrictions or any instructions of the customer as such. He is not even bound to render any account with regard to his investment or with regard to his lending. He is again not even required to return the customer of all the income that he earns out of the administration of customer's money. He is only expected to return to the customer when he demands its withdrawal or repayment, that too only at the rate of interest that is prevailing at the time of withdrawal, as in the case of savings bank. But in the case of FD or any other RD, it will be at the rate agreed between the parties at the time of opening. And in the case of current, as such, there is no rate of interest admissible to be paid. Then, when we have seen that in the case of primary general relationship, a banker is neither a bailee nor a agent nor a trustee, but a banker is a privileged, honored, and a dignified debtor. When we know that a banker is only a debtor in respect of customers' money, what kind of a debtor he is? Whether he is an ordinary debtor, whether it is a debt, whatever amount of money that is deposited by the customer to an account opened, whether it will constitute the banker as a ordinary debtor, and moreover, whether it is a deposit or debt. It is a deposit. Whatever the amount, whatever money which is deposited by the customer with the banker to his account means to the customer's account, as you know that it will constitute the relationship between the two as a banker, customer, debtor, creditor. But it is in the strict sense, it is not a debt, but it is used by a dignified word, deposit. It is not to be called as a bankers borrowing from the customer. As we know, when an account is opened with the banker, it will constitute the banker as a debtor and make the customer as a creditor. But bankers borrowing from the customer by acceptance of deposit will make him a debtor, though, but it will be, it is used by a dignified name as deposit and not the debt. So banker is a debtor, debtor on account of borrowings from the customer in view of primary general relationship functions, that is acceptance of deposits. So it is to be called by a different name, a dignified name like deposit as such. What are the unique features of that banker-customer relationship, debtor-creditor? Banker is a, let us now deal with that, but the debtor-creditor relationship with the banker and customer has certain unique features. They are: 1, the banker is a privileged or honored or dignified debtor. No doubt, in spite of banker being a creditor when he holds a customer's deposit, but he is a privileged or dignified debtor. He is a privileged or dignified debtor for the following reasons. Namely, when the banker, though a banker's borrowing from a customer is nothing but a debt, it is given a dignified term, deposit. Generally, for borrowing money, debtor goes to the creditor. Now you have designated the banker as a debtor and the customer as a creditor. When the banker being the creditor and customer being the creditor, usually it is the borrower should go to borrow the money to the creditor. But it is not so. It is reverse. That is why banker is a dignified debtor. And moreover, when he is being a dignified debtor, whatever amount borrowed is not debt, it is called deposit. Therefore, in the case of a bank deposit, it is a creditor, it is a customer, it is the depositor goes to the debtor, that is the banker, for giving the amount, that is the deposit. Again, a debtor is required to repay the debt on his own accord, generally, in the case of debtor-creditor relationship. But in the case of a banker-customer debtor-creditor relationship, a banker need not repay the deposit to the depositor, that is to the customer, on his own accord. He will repay the deposit only when there is an express demand in writing in the requisite form by the customer for the repayment of money. Unless there is the demand in the proper form is made by the customer in the by complying with the essential conditions for making the repayment, there is no need for the banker to repay the money that is deposited by the customer. A banker cannot be asked by the customer to repay the deposit at a place of customer's choice. It has to be at the bank's branch only, and it has to be at the during the business hours only, of course. And these days we have seen due to the invention of technology, due to the invention of new trends in the emerging trends in the banking, we have introduced e-banking. As such, there is ATM, there is RTGS, there is NEFT. So it can be asked as you can transfer the fund, you can withdraw the money from your account by using ATM card and all. But otherwise, unless you need to go to the a banker cannot be asked by the customer to repay the deposit at a place other than the one where the deposit is kept. Even now, though the core banking or e-banking facility is now encouraged or introduced, wherein we can deposit or withdraw digitally. Still, for some other services you need to go for the home branch alone, and it is not available with the other branches as such. A banker can be asked to repay the deposit only on the working day and only during the working hours. Of course, these were all the features, essential features that were existing. If at all you go to the bank branches, I did not mean that if you go to the ATM, whether you can get yes, if your account shows sufficiency of the balance, then when the money is there with the ATM machine, then ATM will pay. But if you go to the branch, then you cannot be asking the branch to pay to repay the money lying in the account at any point of time. Maybe can you go on a non-working day? Can you go after the business hours of the bank? No, you cannot. So you cannot be asking the banker to repay the deposit at your will. It has to be subject to certain restrictions like that. A banker is not required to give any security to the customer for the deposit of money he made. Of course, today you know that there is one act called Deposit Insurance and Credit Guarantee Corporation of India Act. As per that act, up to 2020 March, all the deposits up to the extent of 1 lakh was guaranteed. But now since April 1, 2020 onwards, it is guaranteed up to the amount of 5 lakhs. If at all any account of yours showing 5 lakhs and more balance, then up to the extent of 5 lakhs, if the bank goes to liquidation, your account up to the limit of 5 lakhs is guaranteed. So this is what I think it will promote. If any bank where you are having banking relationship, then first ensure that whether the said bank is covered by deposit insurance, whether it is covered by deposit insurance provision. If it is not covered by deposit insurance provision, especially from 2020 onwards, I think it will be very risky for a customer to open an account with such kind of bank which is not covered by the deposit insurance. It should be the obligation of the Reserve Bank of India as such that when it permits a banking license for an institution to run banking operations, then it should ensure that they would be covered by deposit insurance. If it is not covered, then they should not be allowing any institution to run banking business as such, because it will deceive, or it will hamper, or it will cause hardship to the customers as such. Second, say we have seen a banker is a privileged or honored or dignified debtor. Second one, customer is only a general creditor of the banker. Regarding these and other things, as far as the primary general relationship and the subsidiary general relationship, we will discuss in the next clip as such. Thank you right now.